My name is Teresa Scholda, and I'm an employment lawyer at Foulston Siefkin here in Wichita, Kansas. And I'm going to be presenting today along with my colleagues, Don Berner, Forrest Rhodes, Jason Lacey, and Morgan Hamas. We are going to be diving into the Families First Coronavirus Response Act. So this law came out, it was signed into law on March 18th, and we've now been kind of living with it for a couple of weeks. It went into effect last Wednesday, and the Department of Labor has certainly given us some insight into how we're supposed to be putting this law into effect. And that's what we're going to discuss today is what the DOL is expecting of us when we put this law into effect. Just a note at the very outset, we are recording this webinar, and we are going to post the recording of the webinar along with all of the slides shortly after we finish the presentation. And those will both be available at the link that you see on this slide, foulston.com, resources, COVID-19 updates. So if you have colleagues who weren't able to join the webinar right now, you can pass along this information that they can watch the replay anytime by going to this link. We also have just a ton of other great resources at that link. We have over 20 updates that go to different aspects of what this pandemic has, the havoc this pandemic has wreaked on businesses and employers nationwide. We have information for landlords, we have information for religious institutions, business institutions, healthcare institutions. So we encourage you to visit that website and scroll through some of those updates and see if any of them might be helpful to your organization. So we're going to go through, like I said, we're really going to focus on the Families First Coronavirus Response Act and the Department of Labor regulations that came out last week. We are at the end, we're going to have a Q&A with the lawyers you see pictured there. We decided to spare all of you a live video feed of us since we've all been working at home the last couple of weeks. We didn't think you wanted to see what we look like after a couple of weeks working in our pajamas. So as we talk about the Families First Coronavirus Response Act, we want to make sure that you are considering the holistic picture. There's so much going on, and we've all been drinking out of this fire hose for the last several weeks of information that's been coming at us. And when you're conducting workforce planning right now, we just want to point out some of the big picture items you need to be thinking about. So not just this paid leave that we're focusing on today, but the CARES Act, which was the third phase of the federal stimulus. And that act addresses various loans that small businesses can take out to continue payroll if they're facing economic hardship. It also has a big boost to the unemployment programs throughout the country. Employers need to consider insurance coverage. Some of the healthcare insurers and other insurers are putting into place moratoriums and special considerations related to the pandemic. And so employers need to be checking with their brokers and their insurance carriers to find out if any of those special provisions are impacting their employees. There are also WARN implications. If you have mass layoffs or furloughs, you need to make sure that you're on top of those issues. And if you end up providing severance payments to laid off employees, there are obligations under the Older Worker Benefit Protection Act that need to be considered. And of course, state law unemployment and other contractual obligations. So we just want to make sure that you're considering the holistic picture when you're doing workforce planning, because there are so many moving parts right now that you have to really look at all of these individual items when you're making those plans. Okay, so let's talk about this Families First Coronavirus Response Act. It was signed into law on March 18th. And it provides two types of paid leave. The first type of paid leave is emergency paid sick leave, and it provides up to 2 weeks, and we'll talk about what 2 weeks means in the context of different employees, but it provides up to 2 weeks of paid sick leave for various COVID-19 related issues such as quarantines, illness, caring for others, or childcare responsibilities due to school and daycare closures. And then this law also contained an emergency FMLA provision, which adds an additional reason for Family and Medical Leave Act, which is leave to care for children because of school or daycare or child caregiver interruptions related to the COVID-19 pandemic. The Department of Labor, you might remember that the law was passed on March 18th, and the law said, hey, this law needs to go into effect within 15 days, which would have been April 2nd, but the Department of Labor came out and said, no, we're gonna make this effective on April 1st of 2020. So last Wednesday was the start date for this law, and it goes through December 31st of 2020. Any leave that might have been granted before April 1st would not be subject to this paid leave provision, and that can impact whether or not you get a tax subsidy, which we'll discuss later on. So let's talk about emergency paid sick leave. There are 6 reasons an employee can take emergency paid sick leave under this law. And that's, remember, the up to 2 weeks or up to 80 hours if you're a full-time employee of paid sick leave. First is whether the employee is subject to a federal, state, or local quarantine or isolation order. Now, we have gotten a lot of questions about whether or not the Kansas state stay-home order falls under reason number 1. And the Department of Labor regulations came out and they said stay-home orders can fall under reason number 1 if the employer still has work for the employee to do, but the employee can't do the work because of the stay-home order. So an example would be in Kansas anyway, there is a travel quarantine. If you're traveling to Kansas from some of the hot spots, the stay-home order in Kansas says that those travelers have to quarantine for 14 days when they travel into Kansas from one of these hot spots. So that might be a situation where the employer has work for the employee to do, but the employee cannot do the work because of a quarantine that's contained in a government order. But if the business shut down because of a stay-at-home order, such as salons or nail care places, that does not apply because the business shut down completely and there's no work for the employee to do. The second reason is if the employee is advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So key here is that a healthcare provider does need to be involved in this reason, and we'll talk about what kind of documentation you need to get from employees in just a little bit. But if an employee calls and says, hey, I've decided to self-quarantine because I have symptoms, I haven't called my doctor, nobody told me to self-quarantine, I just unilaterally decided to self-quarantine, that does not count for reason number 2. The employee has to have gotten healthcare advice from a healthcare provider to self-quarantine. Number 3 is the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. So again, there does have to be a healthcare provider involved in reason number 3 as well. The current symptoms that the CDC has recognized are a fever, a dry cough. Let me get to my notes here. Or shortness of breath, and then any other reasons that CDC has listed in their website as symptoms of COVID-19. And key here is that the employee can be experiencing any one of these symptoms and is seeking a medical diagnosis. It doesn't mean that the employee is experiencing all of those symptoms. So if the employee is experiencing any one of those symptoms and seeking a diagnosis, reason 3 comes into play. Reason 4 is if the employee is caring for an individual who is subject to a quarantine order or direction to self-quarantine by a healthcare provider. So something that employers who are already subject to the Family and Medical Leave Act will note is that this covers caring for an individual. Traditional FMLA says you have to be caring for a family member, a child, a parent, or a spouse. But under this emergency paid sick leave provision, it can be an individual. It is not just any old individual. It does have to be somebody the employee has a relationship with, such as a family member or a non-family member who the employee has a relationship with and who the individual would expect the employee to care for them. So there does have to be some kind of relationship between the employee and the individual he or she is caring for. The fifth reason is if the employee is caring for a son or daughter when there is a school or daycare closure, or if there's interruption with their childcare provider due to COVID-19. I do want to point out that the childcare provider doesn't have to be a paid daycare center or a public school. A childcare provider can be an unpaid family member or neighbor who regularly watches the employee's child, but now that child care services are now cut off. So for example, the example I've been thinking about in this situation is when grandma and grandpa routinely watch their grandchildren, and now because of the COVID pandemic, there's a decision to isolate the grandchildren from the grandparents due to their age or their pre-existing conditions. So that would be a situation where the provision of childcare has been interrupted due to COVID-19 and may qualify for paid leave under reason number 5. Number 6 is sort of a catch-all. So if the employee is experiencing any substantially similar condition specified by the Secretary of Health and Human Services. The Department of Labor has noted that right now there are no similar conditions that have been specified, but if the Secretary of Health and Human Services does come out and identifies other reasons for leave, the DOL will update their guidance. So under the emergency paid sick leave provision, the amount of paid leave will be up to 2 weeks. I should point out, because I'm seeing lots of questions coming in, and I should have pointed this out at the very beginning. We are going to have that Q&A session at the end, and we have upwards of almost 500 attendees. So we're not likely to get to all of your questions, but please know that our panelists are monitoring your questions, and we'll try to aggregate them into subject matter so that we can try to get as much answered as possible. And we obviously won't be able to dive into very, very specific detailed scenarios, but just know that your questions are being reviewed as we go through. So please feel free to submit questions as we're talking through these slides, and we'll try to get to as much as we can during the Q&A session. Okay, back to the slides. So under emergency paid sick leave, employees can take up to 2 weeks. So what does 2 weeks mean? For a full-time employee, which is defined by the Department of Labor as someone who regularly is scheduled to work at least 40 hours a week. Okay, so I know a lot of employers may categorize full-time employees as something else. Maybe you categorize your full-time employee as somebody who works at least 36 hours a week, or the number of hours a week required to be eligible for your healthcare benefits. Under this law, a full-time employee is very specifically defined as an employee who is regularly scheduled to work at least 40 hours a week. Anything less than that, under this law, is considered not a full-time employee, but a part-time employee. So for full-time employees, they can take up to 80 hours. They are maxed out at 80 hours, even if they are regularly scheduled or work more than 80 hours during any given week. So for example, the Department of Labor gave an example of somebody who regularly works 50 hours a week. And they said during week 1 of paid leave, the employee will get paid for 50 hours of paid leave. And during week 2, they will receive 30 hours of paid leave because they are capped at 80 hours under this emergency paid sick leave provision. The amount that the employee receives differs depending on the reason the employee is taking leave. So for reasons 1, 2, and 3, which are related to the employee's own quarantine or illness related to COVID-19, the employee can receive their regular rate of pay capped at 511 days or $5,110 total, which would be 10 working days at 8 hours a day. If the employee is taking leave for reasons 4 through 6, which all deal with caring for someone else, so caring for an individual who has been quarantined or caring for a child because of a school closure, the employee will receive 2/3 of their regular rate of pay, capped at $200 a day or $2,000 aggregate for the emergency paid leave. Key to this provision of paid leave, the employer cannot require employees to use up other PTO, ETO, vacation, or sick leave that already is in existence. Employers cannot require employees to use up that paid leave first. And for emergency paid leave, all employees are eligible regardless of the length of employment. The second type of paid leave, Emergency Family and Medical Leave Act leave, is very, very different. There is only one reason employees can take FMLA, which is what I've been calling it. The only reason employees can take FMLA is to care for a child because of caregiver interruption, school or daycare closure, or that situation we talked about where the regular child caregiver can no longer care for the child because of COVID-19. In this case, not all employees are eligible. The employee must have been employed for at least 30 calendar days. So most employees will be eligible. The Department of Labor regulations, they did get amended by the CARES Act, which said if the employer has a layoff that occurred after March 1st due to COVID-19, but then later re-employs the employees who were laid off, if those rehired employees had 30 days of service before they were laid off, they remain eligible for FMLA for the duration of 2020. So if you've laid off a bunch of employees and then you got a small business loan under the CARES Act and are wanting to rehire some of those folks, once they're rehired, they very well may be immediately eligible for FMLA based on their prior service. FMLA cannot be used for any quarantine or illness related issues, but I will point out that if you're a covered employer under the traditional FMLA, that an employee may have a traditional FMLA reason for continuing leave. So if an employee is himself sick with COVID and it lasts longer than 2 weeks, then the employee may get to take traditional FMLA leave if you're a covered employer for additional weeks. But that traditional FMLA leave is not necessarily paid leave. The other key item that the DOL clarified in their regulations is that taking emergency FMLA leave is just another reason for FMLA leave. It's not an additional 12 weeks. So for employers who are already covered under the FMLA, employees can have 12 work weeks of FMLA total. So if you have an employee who has already taken 12 work weeks of leave due to the birth of a child, they don't have any leave left for emergency FMLA leave. Or if you have an employee who has already taken 4 weeks of traditional FMLA leave due to a surgery, they only have 8 weeks left for FMLA. So it is not an additional 12 weeks. It is 12 weeks total combined with the other reasons for traditional FMLA leave. If you are a smaller employer who is under 50 employees and you have never been subject to the traditional FMLA leave, then your employees have a full bucket of 12 weeks of FMLA that they can use if there is child caregiver interruption. By the way, the other item that the Department of Labor made clear was that, we're kind of thinking the school year typically ends in May, and so after May, there might not be a reason for people to have to stay home with their kids. But this Emergency Family and Medical Leave Act, it extends to summer camps, summer child care institutions or facilities. So this type of leave can certainly continue on after the regular school year ends. So how do people get paid for Emergency Family and Medical Leave Act? During the first 2 weeks of FMLA, it can be unpaid. The employee has the option to substitute existing PTO for those first 2 weeks, or the employee can use emergency paid sick leave. But the employer, again, cannot force the employee to use up their PTO bank for these first 2 weeks of FMLA. Starting with week 3 through 12 of FMLA, the employee can receive 2/3 of their regular rate of pay for hours otherwise normally scheduled to work, up to those caps, the $200 daily cap or the $10,000 aggregate cap over a 12-week period. If the employee uses emergency paid sick leave for those first 2 weeks, then they end up getting capped out at about $12,000 total for the 12-week period if they use up all of their options. One question we were getting a lot from our clients in the early days before the Department of Labor started to clarify was, well, the pandemic has caused us to cut full-time employees to part-time and reduce part-time employees' hours. So if they qualify for this paid leave, do we pay them for the hours they were scheduled before the pandemic or the hours they were scheduled after the pandemic? It is the hours they were scheduled after the pandemic. So if you have reduced schedules because of the pandemic, you only pay for the hours the employee would have been scheduled, including reduced schedules because of the pandemic. The whole point is that you're not paying employees for hours they wouldn't otherwise be working. Okay, so let's dive into the Department of Labor regulations. One big question that we were getting early on over and over was whether or not employees could take paid leave intermittently or on a reduced schedule. And the Department of Labor said yes, employees can take paid leave intermittently or on a reduced schedule if employers and employees agree to it. So under traditional FMLA, if an employee wants to take leave intermittently, the employer doesn't really have a say in most situations. They just have to grant intermittent leave. In this situation, the employer has to agree to the intermittent or reduced schedule that the employee is proposing. So unlike traditional FMLA, you don't have to agree that the employee can just decide one day that they're not going to show up because of an emergency paid leave reason. You can sit down with the employee and hatch out a schedule that will work for the employee and hopefully for the business. So for example, if the employee can take emergency paid leave in the morning because of school closures when they need to online school their children, then they would take 4 hours in the morning of emergency paid leave. And then in the afternoon, maybe they can telework for 4 hours. So that might be a schedule that could work out where they only use 4 hours a day of paid leave, and then they have 4 hours of regular work via telework. The Department of Labor has encouraged employers and employees to collaborate to achieve these kinds of arrangements to make sure that both the employee and the employer can get their schedules met through these agreements. If the employee is taking leave because of their own illness or quarantine, obviously they cannot show up to the regular work site intermittently. And so you know, if the employee is taking leave, emergency paid leave for reasons 1 through 3, which is related to their own quarantine or illness, then they need to stay out of the usual work site. But there still might be a telework arrangement if the employee is, let's say the employee has been self-quarantined because of a travel restriction, but they are not symptomatic. there very well may be a telework option for those employees, in which case they might be able to work intermittently or just work their regular schedule if they can telework. So another big question that was coming up was, can employees use their PTO and paid leave at the same time? And the Department of Labor said, no, not without the employer's permission. But in the case of reasons where the employee is only receiving 2/3 pay, so when there's been a school or daycare closure, or if the employee is taking paid leave to care for an individual who has been quarantined, employees can supplement that 2/3 pay with their existing PTO bank to make up the difference, as long as the employer agrees. So if there is an agreement between the employer and the employee, you can supplement with PTO. You can't force employees to supplement, and employees can't force the employer to supplement, but the two can agree to that supplementation. So what about if your business closes or if the employee is furloughed because of pandemic-related reasons? The Department of Labor came out and clarified this. If the employer shut down or furloughed the employee before the law went into effect, then paid leave is not available. If the employer closed or the employee was furloughed after the law went in effect, but before the employee has asked for leave, paid leave is not available. If the employee is furloughed while on leave, so the employee takes paid leave, and then while they're on paid leave, business circumstances are such that the employer has to close or furlough a group of employees, then the employer would pay for paid leave up to the date that the employee is furloughed or when the business closes. The main issue here is just like with the reduced schedule we talked about earlier, the main issue is that paid leave is only intended to pay employees when they could otherwise work. When there is no work to do or insufficient work, then there is no paid leave option. Okay, let's talk about how we calculate. What does it mean to have 2 weeks of paid leave and 12 weeks of FMLA leave? So as I mentioned earlier, for full-time employees, they can take up to 80 hours of emergency paid sick leave. And again, under this law, a full-time employee is defined as someone normally scheduled to work at least 40 hours. Anything less than 40 hours is considered a part-time employee. For part-time employees, you would look at the part-time employee's normal weekly schedule over a 2-week period if the employee works a normal or regular schedule. And that would be the schedule that you apply to part-time employees. Again, if there's been a reduction in the schedule because of COVID-19 related reasons, then you would apply that reduced schedule because you're not paying employees for hours that they would not be scheduled to work. If the employee has a variable schedule, which we have a lot of clients who have employees on a variable schedule, 7 days off, 7 days on, overnight shifts, things like that, the Department of Labor has set out a step-by-step process for calculating how many hours you would pay an employee for a variable schedule. So the first thing that an employer would do would be to take the 6-month average of what that variable schedule employee has worked to determine their daily hours. If the employee has been employed for less than 6 months, then you can do one of two things. You can use the number of hours that was agreed upon hiring. So if you said, hey, you're going to be a variable schedule employee and you're going to work typically 12 hours a week, then that would be the agreement. If you didn't have an agreement, then you would look at the average hours per day that the employee was scheduled to work over the entire term of employment to figure out that average daily hour. And then once you calculate how many hours the employee is entitled to, you have to figure out how to pay them. Under this law, you're going to pay the employee the greater of their regular rate of pay or federal minimum wage under the Fair Labor Standards Act, or the applicable state or local minimum wage, whatever is greater. And then again, of course, this is up to those daily caps of either $511 a day for reasons 1 through 3 for emergency paid sick leave, or $200 a day for caring for an individual or because of a school or daycare closure. The regular rate of pay is the average of the regular rate of pay over a 6-month period prior to the date that the employee takes leave. If the employee hasn't worked for 6 months, then you look at the average pay for over the weeks that the employee has been employed. Importantly, tips, commission, and piece rates are included to the same extent they're included in a calculation of the regular rate under the Fair Labor Standards Act. So this law has a lot of overlap with the Fair Labor Standards Act in terms of how you calculate pay and hours. Okay, these next few slides are, I think, they cover some of the biggest questions that we were getting after this law was passed, and that is, what can we ask our employee to provide to substantiate that they need this paid leave? And I will tell you that when the Department of Labor issued their regulations, all of us here at Foulston were a little bit surprised at the scant amount of documentation that employees need to provide. The key here is that there is no requirement that the employee provide an actual doctor's note for any of these reasons for leave. So let's cover what they do need to provide. So for all of the reasons to take paid leave, so this is under paid sick leave or FMLA, the employee needs to provide their name, the dates that they're requesting leave, which reason under all of the paid leave reasons they are seeking leave, and a statement by the employee that the employee is unable to work, including telework, because of the qualifying reason. The Department of Labor regulations say that this last statement can be made orally or in writing. And I can assure you that almost every HR professional that I have ever worked with would really like that statement in writing. However, the Department of Labor does say that the statement can be made orally or in writing. I would assume most employees would be perfectly fine with signing a statement to this effect. But to the extent you have an employee who refuses to make that statement in writing, I would encourage all of you who are taking these requests to go ahead and document that statement. Okay, now let's move to the specific documentation for the different reasons. So if the employee is taking leave for reason 1 or 4 under the emergency paid sick leave, that is when the employee has been quarantined by a government order or is caring for an individual who has been quarantined by a government order. They have to provide the name of the government entity ordering the quarantine. Now, I originally thought that they would have to actually provide a copy of the order, but that is not the case. They just need to provide the name of the government entity ordering the quarantine. For reason 2 or 4, so reason 2 is when the employee has been advised by a healthcare provider to self-quarantine, and reason 4 is if they are caring for an individual who has been advised to self-quarantine by a healthcare provider. The employee need only provide the name of the healthcare provider advising them to quarantine or advising the individual to quarantine. So again, no requirement that they actually turn in a doctor's note signed by a healthcare provider. They just need to provide the name of the healthcare provider. Reason 3 is when the employee is suffering symptoms of COVID-19 and is seeking diagnosis or treatment. Again, the employee just needs to provide the name of the healthcare provider, not an actual doctor's note. And then for reason 4, which is when the employee is caring for an individual, the employee has to identify the individual, identify their relationship to the employee, and then also provide the name of the government entity or the healthcare provider who has advised the individual to quarantine or to self-quarantine. Now for reason 5, which is leave because of childcare closure or childcare interruption. So that's reason 5 under emergency paid sick leave or for emergency family and medical leave. In addition to that first slide with the employee's name, dates of leave, qualifying reason, and statement that they can't work, they need to provide the name and age of the child, the name of the school, place of care, or provider who is unavailable. And then this actually really surprised me. The employee has to represent that there is no other suitable person who will be providing care for the child during the leave period. So this surprised me because under traditional FMLA, if an employee is caring for a child, you're not allowed to ask this question, but for paid leave or emergency FMLA leave, you are allowed to require the employee to make, you actually must require the employee to make this representation. And then finally, if the leave is for a child older than 14 and the leave is requested during daylight hours, the employee has to provide a statement of special circumstances existing requiring the employee to provide care. So these are basically, there's no outside information. This is all information that is coming from the employee to provide this information that will document the reasons for the leave. And as of the time of this webinar, the Department of Labor has not issued any forms from the Department of Labor. I keep thinking they will issue forms because they have done that for traditional FMLA leave, but I will tell you as of the date of this webinar, I haven't seen any forms on the DOL website, but I do keep checking it every day. But right now, I would recommend that you all set up your documentation to make sure you record these pieces of information for all of your employees who are seeking leave. So let's talk about record keeping. You need to keep all that documentation we just talked about for at least 4 years after the tax becomes due or paid, whichever is later. So this documentation is primarily to ensure that if the IRS comes knocking later on, you have the documentation to support the tax subsidy that you took. So 4 years is the amount of time you have to keep this documentation to ensure that if you have an audit by the IRS, you'll be able to justify the tax subsidies that you took. The IRS also wants you to maintain any documentation showing how you determined the amount of qualified sick and family leave wages were to be paid to employees, documenting how the employer determined the amount of qualified health plan expenses the employer allocated to wages, copies of forms 7200 and copies of completed forms 941. So these are all forms that you need to make sure you have on hand for 4 years in case you get audited by the IRS with regard to the tax subsidies that are applied to this law. So what kind of notice are you entitled to and are employees entitled to with regard to this law? So the Department of Labor issued their poster last week. It is on their website, and all employers have to post this poster that is shown on the slide in a conspicuous place on its premises. And you also have to mail or email to employees who are working remotely. So you can post it on your intranet, or you can send an all-employee email with the poster. I do want to note that the Department of Labor, they initially issued the poster and it had one typo on it, and they quickly corrected that error. So if you snatched that poster up on the first day they issued it and posted up on your posters, you might want to make sure you have the most current one. The typo was in the 3rd bullet point under paid leave entitlements. It originally said up to 10 weeks of paid sick leave and FMLA, and the Department of Labor corrected that to say up to 12 weeks of paid leave and FMLA leave for qualifying reason number 5. Now, employees have to give you notice of the need for leave, but it cannot be required in advance. So I know those of you who are used to the traditional FMLA, you're used to applying your usual and customary call-in procedures for getting notice of the need for traditional FMLA leave. In this case, the employee cannot be required to give you advance notice of the need for paid leave under this law. It can only be required after the first work day for which the employee takes leave. So you might have an employee who's absent, be wondering where they are, and as long as they give you leave by the next day, they will have complied with this notice requirement. After that point, then it's reasonable to require employees to give notice as soon as practicable of when they need leave. But that initial notice has to be, it can't be in advance, and it can be after the first work day. Okay. Not all employers are covered under this law. Only employers with fewer than 500 employees are required to comply with this law, and public agencies, no matter how big. So public agencies with one or more employee, you are required to comply with this law. For private businesses, private employers, it only applies to those with fewer than 500 employees. That includes nonprofits, religious institutions, any manner of private employer. So how do we count to 500 employees? And this has been a really, really tricky question that we've gotten from many, many of our clients. So first of all, you count the number of employees on the date the employee's leave is to be taken. So this is a moving target. Every time an employee takes leave between April 1st and December 31st of 2020, you're basically saying, do I have over or under 500 employees? And that really matters when there are all these furloughs and layoffs. It matters if you're on the bubble and you have a layoff and you end up below 500, then you have to apply the law, whereas before you have the layoff, maybe you were above 500. In counting employees, you do include employees who are on a leave of absence, temporary employees who are jointly employed, such as temp agency employees, day laborers, all those different kinds of employees would be included in your count. Part-time employees, full-time employees. So all manner of employees are counted. Independent contractors are not counted, but they have to be a true independent contractor. So in addition, the Department of Labor will apply 2 different tests to determine whether or not the employer reaches the 500 employee threshold. One is the joint employer test. So it looks at common employees between 2 employers and whether or not the 2 employers are joint employers. And if so, the employers, both employers' employees will be counted together. And it also applies an integrated employer test, which looks at several different business entities and whether or not those many different entities have common management, centralized labor relations, if there's a lot of interrelation, common ownership, and if these separate business entities have a lot of commonalities on a lot of different levels, the DOL will count all of the employers together to see if they reach that 500 employee threshold. And the reason this is so important is that if you're over 500 and you grant paid sick leave, then you maybe shouldn't be taking the tax subsidy. And if you're under 500 and you're denying paid sick leave, then you're going to be subject to the Department of Labor enforcement or other liabilities. So it is important to make sure that you very squarely know where you fall on that 500 line. So another key provision in this law is that even for covered employers, healthcare employers can exclude healthcare provider employees. So we all were wondering, how was the Department of Labor going to define healthcare providers who could be excluded from this law? And they defined it very, very broadly. So it's basically any employee of any doctor office, hospital, healthcare center, clinic, education, laboratory, health department, retirement facility, nursing home, home healthcare provider. So all of these different providers, any employee of any of those employers is considered a healthcare provider for purposes of excluding employees from taking paid leave. It also applies to any entity that contracts with one of those kinds of providers. So supply chain employees who provide supplies to doctors' offices and health care centers. And it also obviously applies to emergency responders. So what does it mean to be a healthcare provider employer who can exclude your employees if you want to? It doesn't mean that these employees are automatically ineligible to take leave. That's not what it means. It means that the employer has the right to decide whether or not to grant or deny leave to these healthcare provider employees. And the Department of Labor cautions employers to be judicious in those decisions. So, for example, in Kansas right now, some of our healthcare provider clients are fortunate enough that they're not having a deluge of COVID-19 patients, and they actually are having a lack of work because of the cancellation of so many elective procedures. And so those employers who don't have enough work for their healthcare provider employees to do can certainly grant leave under this law if an employee asks for it. But they aren't required to. So for example, if that same provider a few weeks from now ends up in a real tight spot with lots of COVID-19 patients and a lot of work to do, they can deny leave to those healthcare provider employees. We have been recommending our healthcare provider employers, if you're going to approve leave, that you approve it in short blocks of time so that you don't get in a situation where you've approved 12 weeks of FMLA leave and then all of a sudden you need that worker back at work because the situation has changed midway through. So we are recommending approving in short blocks of time because of that. Okay, let's talk about restoration of rights under the FMLA. So generally, employees are entitled to be restored to the same or equivalent position, but for employers with fewer than 25 employees, there is no restoration requirement if one of these reasons apply. So if the leave was due to a school closure and then the employee's position no longer exists because of a COVID-19 related reason, and the employer tried to get the employee reinstated but was unable to. I will also say that just generally speaking, even for employers who are larger than 25 employees, that if you have a layoff or a furlough that would impact the employee regardless of their leave, then that may also impact the employee's restoration rights. There is a small business exemption for employers with fewer than 50 employees. It only applies if the leave is due to a child or daycare closure, and the authorized officer of the business has to determine that granting leave would result in expenses exceeding revenues, or there would be a substantial risk to the financial health of the business, and that there are not sufficient workers able to perform the labor if they were to grant leave. There is no application process to get the small business exemption. The Department of Labor has basically said the authorized officer has to make this determination, keep documentation that proves that this exemption applies, and then if the Department of Labor ever comes calling to investigate, you will have the documentation to hopefully defend the decision that you were a small business that was exempt from this law. So of course, the key provision of the law is the tax credit. If you grant leave and pay for leave, you are eligible to retain payroll taxes in the amount of paid leave that you pay. Now, my first bullet point is that public agency employers are not eligible for tax credits but they still must comply with the paid leave provisions. So the tax credit provision of this law is really only applicable to private employers. Of course, just like all other civil rights laws and the Fair Labor Standards Act and the Family and Medical Leave Act, employers cannot take adverse action, discriminate, or retaliate against employees who exercise their rights under this law. And then there are penalty provisions that are basically the same as the Fair Labor Standards Act and the Family and Medical Leave Act. So basically, if you violate the law and are found liable for violating the law, the employer can be liable for liquidated damages, which are basically double damages, attorney's fees, and you can be subject to collective actions, which are basically class actions where many employees join together in a lawsuit. The DOL does have a temporary non-enforcement provision in place through April 17th. That doesn't mean you don't have to comply. That just means that the Department of Labor will not be cracking down on employers through April 17th, as long as the employer can show that they acted reasonably and in good faith, meaning that they remedy any violations, that the violations were just an accident and were not intentional, and that the department gets a written commitment from the employer to comply in the future. I do want to note that this is just a temporary non-enforcement by the Department of Labor. That doesn't mean that lawyers out there can't come after you, because they can. And we've been reading on listservs and various articles that we're receiving that the plaintiff's employment bar are looking at this law, and they're looking at ways that they can come after employers for violations of this law. And they don't necessarily have a lot of sympathy that this is a time when we're very confused and we're needing time to figure this out. And so just be aware that just because the Department of Labor has put a temporary stay in place on enforcement, that doesn't mean that lawyers will act so judiciously. Okay, I want to move to the question and answer session with our panel, Dawn Berner, Jason Lacey, Forrest Rhodes, and Morgan Hamas. I'll turn it over to Morgan, who's going to moderate our Q&A.
So for our first question, we're going to direct that to Dawn. The question is, what does a healthcare facility need to do to exempt itself?
So let me start off before I answer the question and just remind everyone as we go through this Q&A period that there was an early slide that was in the presentation that talks about some of the big picture questions that come up. And I want to remind everyone, as you're thinking about these issues, while we may be answering questions more specifically about the paid leave type issues, you do have other considerations like the CARES Act, insurance, various other obligations under state law, WARM, contracts, and those kind of things to think about. So in terms of what does a healthcare facility need to do to exempt itself, there's nothing magic that the healthcare entity needs to do. They can take this on a case-by-case basis and make those determinations. One thing that you might do if you're going to exempt yourself totally is you could put up a notice next to your poster that talks about the healthcare provider definition and how you're exempting yourself. That may reduce the number of inquiries you get, but there's no requirement to do that.
So for our next question, we're going to direct that to Jason. What do I need to do to validate the 500 employee count? Great.
Well, so just as a reminder that the 500 employee count is for purposes of determining whether you're subject to these requirements or not. And the most recent guidance we have on that essentially says it's a rolling determination, right? You look at your size on the date the employee takes the leave, if you're close to the line, and that dictates whether the employee is eligible for the leave. It's not especially clear what guidance is required to document that number. Payroll records probably are the right way to demonstrate that. Perhaps what you are putting on your account for unemployment insurance it would be a good way to document that. But essentially, you want to use a consistent set of records that's going to show what your head count is on any given day of the week when somebody is taking this leave if you're close to the line.
I'm going to take the next question. It is, if an employee has tested negative for COVID but was still advised to stay home for 72 hours just in case, is that employee eligible for emergency sick pay leave? So if the individual has been advised by a doctor to self-quarantine for COVID-related reasons, they are eligible under Reason 2, advised for a healthcare provider to self-quarantine for leave. If the doctor is advising the individual to stay home, they are covered under the Act regardless of whether there is a test, no test, or a negative test. The healthcare advisor or the healthcare provider must advise the employee to self-quarantine based on the fact that the employee has COVID, may have COVID, or the employee was particularly vulnerable to COVID. So for the next question, we're going to direct that to Teresa. If an employee shows up for work with symptoms and we ask them to go home until they are symptom-free for 24 hours, is that paid leave under the new law, or do we follow our normal policy?
So under the self-quarantine requirement, it really does involve a healthcare provider. So, if the employee shows up with symptoms and we ask them to go home, that we are not a healthcare provider who is advising them to self-quarantine. And so it might not be eligible for paid leave under this law, but they then could use their existing PTO or vacation bank to cover that absence. Now, if the employee does go to a healthcare provider or engages in telemedicine and a doctor or a healthcare provider then says, hey, I agree, you have a fever, you should self-quarantine, then as soon as the healthcare provider is involved, then we are transitioning over into an emergency paid sick leave reason.
Next question we have is for Dawn. Can the employee receive a few days of leave to self-quarantine when a provider advises it due to suspected contact with COVID patient, and then when the test comes back negative, they be returned to work? Would those 2 days be covered by paid sick leave, and then the employee still has the remaining days to use if they have a qualifying reason again?
So I think this question drives to the point of maybe the use of some intermittent leave or having more than one reason for leave and using part of that eligibility and retaining the rest. So the regulations within the preamble and some of the Q&As are a little unclear. I think the answer is that to the extent that you allow them to retain time to use for a second reason, the biggest risk you might have is that the tax credit wouldn't be allowed at some point in the future. The risk you take if you don't allow the employee to use that time up to the 80-hour amount would be that you violated the act and didn't provide leave. But again, it's a little unclear. At several points in the regs and preambles, they're inconsistent on this point.
This is Teresa. I'm going to jump in. We are at 1 o'clock, but we're going to go ahead and continue to answer questions for another 15 minutes or so because we've gotten a lot of really great questions from all of you. So we will continue to answer questions if you're able to stay on for another 15 minutes or so.
So for the next question, I'm going to direct that to Forrest. If an exempt employee is taking intermittent leave under reason number 5 and takes part of a day, are we obligated to pay them for the full day?
And the answer to that is no, we're not. The regulations specifically contemplate that payment of leave is not going to impact somebody's exempt status, and it's long been the rules under traditional FMLA that intermittent or partial day absences due to intermittent leave under FMLA has traditionally been a circumstance when you can do a partial day deduction from an exempt employee's salary.
Next we have for Teresa, if an employee's household member is undergoing chemotherapy and another has asthma, do these reasons apply for leave?
So this would be a question under paid sick leave reason 4, which is when you're caring for an individual. And we've gotten this question a lot. where employees don't want to come to work simply because they live with a high-risk person in their household. But merely living with a high-risk person in your household does not qualify for paid leave. You have to have a healthcare provider say that that high-risk person should quarantine, and it can be because of their healthcare status. So you can't have a healthcare provider say, hey, this high-risk person should quarantine simply because they are high risk, not because they are symptomatic, just because they are high risk. But in addition to having that healthcare provider input, that individual has to need care from the employee. So the employee has to be something that that high-risk individual relies on for care. So simply living with a high-risk person does not get you there for paid leave.
Next question we have is for Jason. How does paid leave interact with PPP, the Paycheck Protection Program?
Okay, so this is a good question. Comes up with a lot of folks, and it's a little complicated, but I'll try to break it down here. Under the Paycheck Protection Program, a portion, perhaps all of the loan that an employer receives or a business receives may be forgivable to the extent it's used to pay for payroll costs and other qualifying expenses during the 8-week period after the loan is made. There is an exception, however, that you cannot count toward your payroll costs that are forgivable any paid leave that's paid under the Families First Act. So any emergency paid sick leave or emergency FMLA leaves. You essentially have to back out of the amount of payroll that you're going to claim toward your loan forgiveness under the PPP any amounts that you pay toward these paid leave amounts. Which I think makes sense, incidentally, because the government is separately funding the paid sick leave and the paid family medical leave through the tax credits, at least for those private sector employers that qualify for them. But that's ultimately how the two programs relate: is that you cannot claim loan forgiveness under the PPP for wages that you pay under the paid sick leave and paid family medical leave programs.
I'm going to direct the next question to Dawn. Can emergency responders or healthcare providers provide exceptions in some cases, but not all cases, for providing leave?
So in the context of these exceptions from the rules, the healthcare providers, emergency responders, those entities can apply those exceptions across the board. They can apply them to some categories of leave, but not others. They can apply those on a case-by-case basis across the staff, depending on the function, the need for those individuals. There's a lot of flexibility here. You can also, if you want to allow a shorter term leave and have them reapply so you can continue to evaluate your need for staffing and provide some leave along the way, that's fine too. I think you have a lot of flexibility here. The DOL would tell you to be flexible and to work with your employees the best you can. And so you can use that flexibility however you want to use it.
The next question is for Teresa. Do you have to send a designation notice for the emergency FMLA leave?
So for those of you on the call who are not covered employers under the traditional FMLA leave, you may be wondering what a designation notice is. A designation notice is basically the notice that employers give to employees that approves or denies FMLA leave, and it says how much leave is approved or denied. There is no requirement under the emergency FMLA provision that requires the employer give a designation notice. That said, I think it's probably a good idea to document how much leave you are approving for that employee. So you're never gonna probably get in trouble from your employment lawyer if you have good documentation. So if you want to issue a designation notice, maybe not the form notice that the Department of Labor has for designation, but some simple notice that says you've been approved for emergency FMLA leave from this date to that date on this schedule, that's probably a good idea and will help you keep track of things.
I'm going to take the next question. It asks, how is particularly vulnerable to COVID-19 being defined or interpreted? Specifically, if an employee has a doctor's note that says they should stay home regardless of an underlying condition, is that enough? If the employee has a doctor's note that says they should stay home, then for a COVID-related reason, that is enough to qualify for the leave. The employers don't need to interpret an employee's underlying health condition, and instead either rely on the doctor's note or the employee's certification that a doctor has advised them to stay home for COVID-related reasons. Since employers don't need to be collecting specific doctor's notes and can rely on those certifications, then it's not necessary for an employer to interpret a particular vulnerability. So the next question we have is for Forrest. How much investigating into a request for leave or an employee calling in sick do I need to do?
And this is one where, there's going to be some frustration from this because employers are going to be faced with situations where you might question the legitimacy of the leave, but I think the regulations regarding what documents employees have to provide simply require that we get a certification from the employee as to the need for leave. With, in the case of childcare leave, you might need the name of the school, the name of the child, some age issues. In the case of a medical requirement, you want the name of the doctor, but it's not going to be a sleuthing responsibility for employers to try to go in and figure out whether the need is legitimate. If the employee is willing to give you the certifications. Now, if you know absolutely the employee is engaging in fraud, then you have to kind of approach that, I think, on a case-by-case basis. But be careful as you tread that way, because the regulations contemplate a process that's different than traditionally where you're asking for a lot of documentation.
Forrest, this is Teresa. I want to jump in on this question because I've seen some questions from the attendees that talk about getting doctor's notes that say the employee is sick, but they don't say anything related to COVID. Maybe it's allergies, maybe it's not, or the employee comes in and they say, my doctor said that I should stay home, but they don't necessarily say it's related to COVID. Do you have to sleuth enough to make sure there's a connection to COVID?
That's a great qualifier. And the answer there is yes. I mean, we have to be comfortable that the underlying reason is COVID related. And if the employee tells us something that doesn't sound like COVID, I think we can safely say, well, we're gonna give you leave under our policies like we normally would, but you're not going to qualify for the Families First paid sick leave or paid FML. Well, probably paid FML probably doesn't come into play, but the paid sick leave, if they don't give us a COVID-related reason, then it wouldn't qualify.
Okay, Dawn, can an employer choose to be more generous than the 2/3 pay required under the Emergency FMLA Act after the first 2 weeks?
They are absolutely allowed to be more generous. The key here to remember, though, is to the extent you're providing something beyond what's required, you're not going to get the tax credit for those amounts in excess of the 2/3 that you're paying under the rules.
So my next question is for Forrest. Can an employer mandate, can an employer mandate that an employee use other paid leaves in conjunction with these leaves?
We cannot, and I think the key to Morgan's question is it in conjunction with or concurrent with? You absolutely cannot require an employee to exhaust some other form of paid leave before they can utilize leave that they would qualify for under Families First. Now, in the expanded FML context, as in traditional FMLA, you can require employees to concurrently use paid leave in conjunction with the benefits they're getting under expanded FML. So, for example, if you've got someone who's getting 2/3 pay under expanded FML and your PTO policy requires employees, or your FMLA policy requires employees to concurrently use leave, you could require those employees to make up the 1/3 difference by using up their PTO along the way, but you couldn't require that PTO to be used first before they get into FMLA, into the expanded FML. The regs are a little less clear as to whether concurrent use of paid leave is allowed in the case of expanded, or in the case of Families First sick leave, the paid sick leave, in a situation where you've got someone for reasons 4 or 5, they're using sick leave to care for someone else and they're only going to be getting 2/3 pay. It's clear you can offer the opportunity for them to use that concurrently to make up the difference with their paid leave. It is not clear in the regulations whether employers can mandate it. It is clear in the FML case that you can.
So Jason, the next one's for you. Can employees be paid at full time even if they are not currently working a full 40 hours due to a temporary drop in work?
Yeah, okay, so this question I think relates not to any of the FFCRA paid leaves, but really the PPP loan, or potentially the tax credit, one of the tax credits that's available under the CARES Act for employers that have had the shutdown operations due to a shutdown order or have had a significant retrenchment in their business. Under either of those programs, the PPP or the tax credit for employees who are being essentially paid not to work, it does appear to be permissible to pay employees even though they're not working full-time or maybe not even working at all. The idea behind those programs is that we're going to essentially have employers continuing to pay employees their full pay or something up to their full pay, with the government subsidizing that. So in the case of the PPP loan, the loan proceeds that are used during the 8-week period after the loan is funded to pay for compensation, those will be credited toward the forgivable amount of the loan. In the case of the tax credit, if you meet the qualifications and are paying so-called qualified wages up to $10,000 for an employee who is not working, then you can claim a 50% tax credit with respect to those wages. There's some other qualifications around those programs, so I don't want to take the time to get too deep into the weeds on those. But the bottom line answer is it is okay under those programs to be paying employees even if they're not working for all the hours that you're paying them for.
Okay, we have 2 more questions to wrap up about unemployment and telework. And so this next one is for Forrest. How does unemployment interact with paid leaves under these regulations?
Well, those 2 are going to interact. They're going to essentially operate independent of one another. Your eligibility for unemployment is going to be contingent on your work hours have been cut. Your ability to work, your work hours by the employer have been cut based on a lack of work due to a COVID-related reason in the circumstances right now. That's when you might qualify for unemployment if the employer has made the decision to cut your hours for these reasons. You're taking leave under Families First. The premise there is work available for you to perform and you are unable to perform it because of one of these qualifying reasons. So to the extent you have a week where you have a little bit of both, they could operate together. Generally, if full-time work is available and you're not doing it because you're on a covered leave under Families First, you're not going to qualify for unemployment.
And lastly, for Dawn, how does telework and flexible hours interact with the need for leave?
So the questions related to telework and how it plays in, it's a fairly tricky question to work your way through. And so I first would say, as employers, be careful as you're trying to work through this. So I think one point is, why is it the person's asking for the leave? To the extent that the individual is asking for leave because they're unable to work due to some COVID-related illness, then requiring telework instead of leave would not be appropriate. To the extent that someone might be at home under a quarantine order as a precautionary measure, then the amount of telework they can do would take away from the amount of leave that they might receive. The other place where telework may come into play is on the intermittent usage of the child care related leave. And just be mindful that when we're talking about that intermittent usage there, it's a mutual agreement intermittent usage as opposed to a mandating use of telework in lieu of the leave time.
So it looks like we are out of time for questions, so we're going to turn it back over to Teresa to
All right, I think
give
we're
our
going to
final
wrap it up
closing.
now. Thank you so much for attending. I know we couldn't get to all of your questions. You guys had a lot of great questions, and we have been hearing similar questions over the last 2 weeks, and we wish we could answer all of them, but unfortunately, with several hundred attendees, we just weren't able to get to everything. But we hope that we were able to provide some help and guidance as you navigate these incredibly difficult, complex, and ever-changing waters. We sympathize with what you're all facing, and we know it's difficult. If you need additional help, we welcome you to reach out to any one of us. There is contact information on this last slide. If you don't already have a relationship with Foulston Siefkin, please reach out to Molly Morgan at that contact information, and she can help set up an engagement with some of our attorneys. If those of you who already work with us, feel free to reach out to any one of us, and we'll help you through these times as much as we possibly can. Thank you everyone for attending, and we wish you the best. Stay safe, stay healthy, and best of luck.